Companies Act, Section 229, Penalties for fraudulent conduct during inspection, inquiry, or investigation. Corporate inspections, inquiries, and investigations are vital mechanisms by which the central government and designated authorities ensure the transparency, compliance, and integrity of corporate entities. These processes depend on truthful disclosures, full cooperation, and the preservation of documentary evidence to uncover potential mismanagement, fraud, or other misconduct. Section 229 of the Companies Act, 2013, is a critical enforcement provision designed to deter and punish acts of deceit, obstruction, and destruction of evidence during the course of such regulatory actions. It imposes stringent penalties, including those for fraud, on individuals who attempt to sabotage or compromise the integrity of an inspection, inquiry, or investigation. Purpose and scope. The section applies broadly to any person who is required to give an explanation or make a statement during an inspection, inquiry, or investigation, or an officer or employee of a company or body corporate that is under investigation. The intention of the legislature here is to ensure that persons do not mislead regulatory authorities. Crucial evidence and documentation is not tampered with or destroyed. The investigative process is conducted in a truthful and transparent manner. Those who willfully obstruct investigations are held criminally accountable. Acts constituting offences under Section 229. Under this section, the following acts are considered grave offences and are punishable as fraud under Section 447 of the Companies Act, 2013. A. Tampering with or destroying documents. If any person destroys, mutilates, or falsifies any document, conceals, tampers with, or removes without authorization any books, papers, or records, or participates in any such activity knowingly or willfully, and such documents relate to the company's or body corporate's property, assets, or affairs, then such actions shall amount to an offence under this section. This clause particularly targets deliberate attempts to destroy or alter material evidence, thereby obstructing justice or misleading authorities. B. Making false entries. Makes a false entry in any document that relates to the company or body corporate, or is knowingly involved in causing such a false entry to be made. This too is punishable under this section. This includes cases where financial statements, registers, or internal reports are manipulated to present a misleading picture of the company's financial or operational position. C. Providing false explanations or statements. Provides an explanation or makes a statement during the course of inspection, inquiry, or investigation, and that explanation is false, or the person knows the explanation to be false at the time of making it, then that person shall be considered guilty of fraud. This provision is particularly relevant to interviews, depositions, or written responses submitted to inspectors or government authorities during the investigative process. Punishment for offences under Section 229. A person found guilty of any of the acts described above shall be liable to punishment for fraud, as detailed under Section 447 of the Companies Act, 2013. Section 447. Punishment for fraud. According to Section 447, the punishment for fraud includes imprisonment for a term that shall not be less than 6 months, but which may extend to 10 years. In cases where the fraud involves public interest, the minimum term of imprisonment shall not be less than 3 years. Fine which shall not be less than the amount involved in the fraud but may extend to 3 times the amount involved. The penalty may be imposed independently or in addition to imprisonment, depending on the nature and gravity of the fraud. This reflects the legislature's intent to treat such acts as serious economic offences deserving of harsh punishment. Relevance and legal impact. Section 229 plays a crucial deterrent role in ensuring that corporate actors refrain from interfering with investigations, maintain accurate and honest records, fulfill their statutory duty to cooperate with inspectors or investigative authorities. It reinforces the idea that fraudulent conduct will not be tolerated, especially in the context of government inquiries or actions designed to protect investors, creditors, and the general public. For more details, contact us.